Chaffetz for 5 minutes.
Thank you, Mr. Chairman. Mr. Koskinen, in your opening statement, you said that you had instructed people in writing to preserve their records. Could you please provide this committee and the Oversight and Government Reform Committee a copy of those emails?
Copy of the email. Sure, we'd be delighted. I think my statement said that we instructed those. I did not personally send an email.
You didn't. Okay, we'll go back and look at the record. If there are any emails asking people to preserve those documents, we'd like to see those because we don't think we have them. Do you
We'd be happy to provide those.
Do you stand by all of your previous congressional testimony?
I've noted that if I knew then what I know now, I would have testified in a different way.
What in your previous congressional testimony needs to be clarified or altered or updated?
Well, I tried to make that clear. Clearly, at the time I testified, I was advised that, in fact, all the evidence was being preserved pursuant to the orders that went out. Since then, it's been clear that obviously some tapes were erased, which was a mistake. I said that at the time. If I were testifying again, I would say...
Part of the problem that we have is that you've never clarified your testimony. This is the first time we've ever heard you say mistake. This is the first time that you said that you've provided essentially false testimony. That's the way I read it. When you said on June 20th of 2014, quote, since the start of this investigation, every email has been preserved, nothing has been lost, nothing has been destroyed, end quote. Was that a mistake or was it false?
That was an honest statement on the basis of what I knew. As Congressman Gowdy said, I would have been better advised if I had said on the basis of what I've been told and I understand.
But you told us in a hearing on July 23rd, you told Mr. Jordan that you learned in April that these emails were missing.
You have to understand there are two sets of emails. The emails that I knew were missing in April of 2014 were from the Lois Lerner hard drive crash. No one knew until 2015 about the erasure of the tapes in Martinsburg. When I testified in June, our whole focus, because none of us, the committee nor I, knew about the erasures.
Why are you testifying that since the start of the investigation, nothing has been lost, nothing has been destroyed?
At the time I testified, that hearing was about the Lois Lerner hard drive crash, so it was clear Lois Lerner's hard drive had crashed.
But you also testified a couple weeks later that you knew in April there was a problem. In fact, Kate Duvall, your senior person, knew in February, but you said you personally knew in April, and yet you came before Congress and you gave these definitive statements.
Well, if you look at the timing of it, you had the report from us on the entire production system and the Lois Lerner hard drive crash.
But what you said was false. Was it true or false, what you said?
It was true as far as I knew, and when I testified...
But in April, you said you knew in April that there were missing emails.
Yes, and I filed a report with the Congress.
How can you simultaneously say that you know there are missing emails in April, and in June you say, since the start of this investigation, every email has been preserved?
Because Lois Lerner's emails were lost in 2011, long before the investigation started, and that hearing was about the Lois Lerner hard drive crash.
Let me ask you another quote. True or false? We confirmed that the backup tapes from 2011 no longer existed because they had been recycled pursuant to the IRS normal policy. On July 23rd, you said, quote, confirmed means that somebody went back and looked and made sure that, in fact, any backup tapes that had been recycled. Is that true or false?
That was true in my belief at the time. Congressman Gowdy.
Who went back and looked?
I was told that the IT department
Told by who?
I was told by people, and I've interviewed
Who are these
all of
people?
those people. Who are those people?
Yes.
It was the Deputy Chief Information Officer whom you've interviewed who said to me that they had looked and they were confident that, in fact, I asked, is there any way to get tapes? He said they've all been recycled.
But nobody went back and looked. In fact, Mr. Camus, who's the head of, who was the deputy there at the Treasury Inspector General, said the best we can determine through this investigation, they simply didn't look for those emails. So for the over 1,000 emails that we found on the backup tapes, we found them because we looked for them, end quote. How is it that you spend $20 million, 250 full-time people, and you never looked for them, according to the Inspector General? And you testify that you went back, in fact, and confirmed. That is false.
That's what I was told at the time. That was my understanding at the time. As I've said, if I knew then what I know now...
And when did you inform Congress that this is your view now, when did you tell Congress that you were wrong on this?
When the IG reported in 2015, I subsequently had a hearing with the Senate Finance Committee about this, and I testified. In fact, I publicly stated in response to the public issues that it was a mistake for those tapes to be erased, and I testified with the Finance Committee.
You know it was a mistake, but they were erased after a duly issued subpoena. That's where we have a fundamental problem. You issue 66,000 summons and email and subpoenas each year. You know how to dish it out, but you don't know how to take it. And so we issue a subpoena, we expect you to comply with it. And when you destroy documents that are under subpoena, somebody's got to be held accountable for that.
The IG
and that starts with you. You provided false testimony to this committee, you've provided false testimony to the Oversight and Government Reform Committee, and you should be held accountable for that. I got about 30 minutes more questions, Mr. Chairman, but I will yield back.
Chair thanks, gentlemen, and recognize the gentleman from Louisiana, Mr. Richmond, for 5 minutes.
Mr. Chairman, I'll just pick off where my good friend from Utah left off, and that's conversation about being held accountable. You don't know me, but I did criminal defense for a while, and I was a state rep. And in Louisiana, I watched many people get indicted and go to jail for the misuse of nonprofit funds. And in your testimony, you say that one of the important things with the IRS is for people to feel that they will be treated fairly and that it doesn't make any difference who they are, what organizations, or what political party they belong to. Well, let me just tell you, there are a bunch of people, including me, that think that the justice system is rigged for those who are privileged and those who are rich. So for the people that I have seen go to jail for misappropriating $2,000, $3,000, $5,000, $8,000, and we have an indictment that's pending right now, the question becomes, how can someone take money that belongs to a nonprofit to satisfy a personal judgment and that not be a misappropriation of the nonprofit's funds?
I don't know the details. All I can say, as I've said, the law is clear. A C organization cannot use its assets to benefit anyone who is closely associated with the organization.
And to pay off a personal judgment would be a benefit to a person, not an organization.
Whatever you use to not pursue charitable purposes, but to benefit anyone associated with it, the law says you should not is not allowed.
Let me just say this, and I wasn't even going to bring that up because I think today is a very unfortunate day, but it signals what this Congress has been about and why our approval rating is so low and why our reputation is the do-nothing Congress. We do something. We grandstand and showboat on a regular basis. This Judiciary Committee in this room weeks ago, after Philando Castile and Alton Sterling were killed by law enforcement, I begged for a public hearing on the issue because I really think that the public deserves it, and I think if we don't do it, we're going to have blood on our hands. Well, unfortunately, police officers were killed. This week, we have 2 more incidents where 2 people were killed in an incident with law enforcement, or 2 people lost their lives in an incident with law enforcement. But we're not talking about it. We're talking about a fragile country. We're talking about fragile people, and we are ignoring a humongous issue because we're talking about impeaching you. In Louisiana, we just had 7 trillion gallons of water dumped on Baton Rouge and the surrounding areas. Just in Baton Rouge, we lost 60 sheriff deputy cars. We lost 50 police cars. We have a law enforcement that is dismantled. But we're not having a hearing here today to talk about how we help them get back up because there's a pending Alton Sterling decision that has to come out. And how do we protect American citizens and how do we keep that community safe when that decision comes out, because we know it's coming. But we're, again, talking about impeaching you with 50-something, I don't know, 100 days left in our term. We keep grandstanding while America is burning. There's some who would rather talk about Colin Kaepernick not standing for the national anthem than to talk about people losing their lives by the hands of law enforcement. This is the Judiciary Committee. We don't even acknowledge, we're not even talking about the fact that we are losing law enforcement officers. We don't even have enough bulletproof vests for the sheriffs in the United States of America, but we're talking about impeaching you. We just had police officers and sheriffs gunned down in Dallas and in Baton Rouge, but they don't have police vests, and we're talking about impeaching you. Somewhere, somehow, you have to say, what are these guys thinking? What are these guys and women doing? Do they not realize that we have a crisis in America and we're talking about impeaching you? Which, you know, is laughable at its best if it wasn't so sad that all of a sudden this becomes the biggest priority that we have. And Mr. Chairman, I would just again urge, and I want to be on the record every time we talk, that we need a public hearing so that people understand how serious we are taking the policing in America issue. Because again, if people don't understand we're taking it serious, they will continue to take it in their own hands. People that are mentally disturbed will do unimaginable things, and it's all on us if we don't get together and talk about it. With that, I will yield back.
Chair thanks the gentleman. Recognize the gentleman from Texas, Mr. Gomert, for
Yes,
5 minutes.
yes.
Thank you,
For
Mr.
purpose, the gentleman from Utah, secret.
I just asked unanimous consent to enter into the record the GAO report from July 2015. Internal controls for exempt organization selection should be strengthened. Critical that, as Mr. Jordan talked about, that the IRS has not fixed the targeting problem.
Without objection, it will be made a part of the record, and now Mr. Gomert is recognized.
Appreciate my friend from Louisiana pointing out the grandstanding. That's kind of what I felt about the sit-in that occurred on the House floor, and my friends across the aisle refusing to recognize that radical Islam is at war with us. And instead, they talked about guns. I'm looking forward to the grandstanding about pressure cookers and the need to make them illegal. But this hearing is about whether or not Mr. Koskinen, you committed such acts as should cause you to be removed from office. And it's already been mentioned that you had testified, that you were made aware of problems associated with Ms. Lerner's emails the same month that Ms. Duvall discovered the gap, and that you had withheld that information, didn't disclose it for 4 months until June 13th of 2014. And that during that time you testified before Congress 4 times. So I want to ask you, during those 4 times you testified, after you learned about the problems with Ms. Lerner's emails, did it cross your mind at all that perhaps you should disclose that there were problems with Ms. Lerner's emails?
If I could correct the record, I have testified, and honestly, I learned about the Lois Lerner email crash in April. Between April and the time we provided the report to the Congress, I did not have a hearing. The hearings in June were about the Lois Lerner hard drive crash. But I've also stated, and the reason I did not immediately report that crash was because I instructed people to see how many emails from the crash period we could recover, and we recovered 24,000. But as I've said in retrospect, because it did create a certain amount of aggravation on the part that I understand of at least some congressmen, in April, when I was advised, if I had to do it again, I would advise the Congress that we had a hard drive crash and we
So
were
is
now
it your opinion that once you've testified before Congress, if you learn information that makes your prior statements not completely true, that you have no obligation to come forward, send a letter, send an email, send a message that you have now learned things, or in your opinion, should you just wait until you're ask, and if you're not ever asked, you have no need to disclose? Which is your opinion?
I didn't wait until I was asked. We actually produced a full report to all of the investigators' committees about the process. But as I've said, when I learned of it in April, life would have been a lot easier if I had simply advised the Congress.
Well,
And since that time, we've advised the Congress.
When you
of any-
found out there were problems, did you know Lois Lerner used a BlackBerry, that she had a handheld device?
I did not, but that BlackBerry was in the hand of the IG from 2013.
Did it cross your mind that she may have had a portable device that was used to send and receive email?
No, I was not analyzing Lois Lerner's activities. I was working and instructing people.
You knew there were requests for Lois Lerner's emails, and it never crossed your mind she might have them on a personal device that she carried? That never crossed your mind? Did it cross your mind that there was this facility in Martinsburg, West Virginia, where storage was kept? Did that cross your mind?
No, I was focused, as the agency was, on reviewing all the emails we could. To get emails, we had to pull each hard drive out of the computer.
Mr.
and we were
Koskinen, when
racing-
you are asked under oath about the existence of emails, there really is an obligation to learn about the emails and where they are and where they exist. Let me just read for you. I hope you're familiar with Internal Revenue Manual. You are, hopefully.
Yes.
Thank you. Well, this was added January 23rd, 2014, 25.1.1.2. Fraud is deception by misrepresentation of material facts or silence when good faith requires expression. And I would submit to you, Mr. Koskinen, you have had ample opportunities over the last 2 years to disclose things or maybe to make inquiry, but it certainly appears you have what might be called willful ignorance, so you don't have to come up here and testify about what actually happened. It's hard to believe that you never made any inquiry about potential places that Ms. Lerner's controversial emails that may have been lost, may have not have been lost, where they might be found. It shocks my conscience that the head of the IRS would not think to ask any questions other than, can anybody find her emails? You require so much more from taxpayers, and then we give you $290 million more dollars, and what happens? You start closing local tax assistance offices for taxpayers, like in Longview, Texas, and the excuse is, well, we got our budget cut. Yeah, this year you got $290 million more. 2 months later, you're closing offices to hurt taxpayers. It looks like there is a problem with the management at the IRS, and I see my time's expired, so I have to yield back.
The time of the gentleman has expired. The chair recognizes the gentleman from New York, Mr. Jeffries, for 5 minutes.
Mr. Commissioner, thank you for your presence and for your service. The chief sponsor of the impeachment resolution that resulted in this hearing is Republican Representative John Fleming from Louisiana. Is that correct?
It's my understanding he's one of the proposers.
And Congressman Fleming is currently a candidate for the United States Senate. Is that right?
My understanding. I'm learning from Congressman Gowdy.
Are you aware that Congressman Fleming is currently running television advertisements as part of this campaign that claims that the head of the IRS, that would be you, ordered 24,000 emails erased?
I am aware of that.
But the facts have already been established, I think, that the emails were inadvertently wiped by 2 low-level employees. Is that right?
That's correct.
And these employees worked the midnight shift. Is that correct?
Yes.
And they worked the midnight shift at a facility in the booming metropolis known as Martinsburg, West Virginia. Is that right?
That's correct.
Now, the Treasury Inspector General is a Republican. Is that right?
Yes.
And he issued a report on June 30th, 2015, which concluded, quote, that no evidence was uncovered that any IRS employees had been directed to destroy or hide information. Is that correct?
That's correct.
The Republican-led Senate Finance Committee has uncovered no such evidence, true?
That's correct.
The Department of Justice conducted an independent investigation and also concluded that no IRS employee from top to bottom had been directed to destroy or hide information. Is that correct?
That's correct.
This is not a legitimate impeachment hearing. This is a political charade. It's a sham. It's a Hollywood-style production. The outcome has already been predetermined. The script has already been written. The witness has already been labeled a bad guy, because in any Hollywood-style production, there must be a villain, and who better than the commissioner of the IRS? But here's the problem. The founding fathers of this nation gave to this House the power of impeachment as an extraordinary remedy, only to be used in serious circumstances. It is not a high crime or misdemeanor to be the head of an agency that some of my friends on the other side of the aisle don't like, as part of an administration that some of my friends on the other side of the aisle don't like. But it's been clear to me, as my good friend from Louisiana indicated, Rome is burning right now in the midst of a police violence crisis, but we're on this reckless legislative joyride to impeach the commissioner of the IRS. Why is that? Well, perhaps there's some in this town who have been determined to impeach a member of the Obama administration from the day that the President of the United States was sworn in January of 2009. But you couldn't impeach Barack Obama. You couldn't impeach Eric Holder. You couldn't impeach Hillary Clinton. And so some genius came up with the brilliant idea that we're going to go after the IRS commissioner. It's a dereliction of duty. It's the only reason why we're here today, and it's a waste of the time and the treasure of the American people. I yield back.
The chair recognizes the gentleman from Idaho, Mr. Labrador, for 5 minutes.
Mr. Chairman, thank you, Mr. Koskinen, for being here. Your testimony suggests, and what was just indicated by my friend, suggests that impeachment is improper, and that you have attached many exhibits to that effect. You further stated that you are unaware of anyone on your level having been impeached in the past. In fact, you sent us a letter from a bunch of college professors, law professors, that says the reason for this salutary exercise of self-restraint by the House, meaning that we have never impeached anybody at your level, is that in our constitutional system, primary responsibility for supervising executive branch officials resides with the President, not with the Congress. But the question that we have to answer in this hearing is what happens when the President is not exercising that supervision over somebody like you. So maybe the question is not whether impeachment is proper, but maybe the question is why, after all of these disturbing instances of lack of candor, lack of transparency, and lack of fitness to serve, you still believe that you can competently serve as the commissioner of this agency. This country may not have a long history of impeachment at your level, but certainly we have a long, long history of officials at your level who have been subject to dismissal and resignation for similar or even lesser offenses than what you have perpetrated. Are you familiar with Michael Brown, the former director of FEMA?
I do not know him, but I know the position he held.
And do you know what happened to him following his mismanagement of the Katrina efforts?
I do not recall specifically. I know ultimately he left the government, but I don't know the
He resigned from office. Are you familiar with former DEA Administrator Michelle Leonhardt? Do you know what happened to her following the release of a watchdog report on agent misbehavior under her watch?
I do not.
She resigned from office. Are you aware of what Catherine Archuleta, the former OPM director, did following the 2015 OPM hacks by foreign governments?
That I do understand.
And what did she do?
He resigned.
She resigned. There are many examples of this, including the resignation of Secret Service Director Julia Pearson following security breaches, and ATF head Kenneth Melson over Fast and Furious. Well, I'm not going to spend my entire 5 minutes providing you with examples of agency heads at your level who have resigned based on agency failures. But however, I'm going to suggest to you why this is not a dereliction of duty. Your bosses refuse to actually hold you accountable for your actions. So there's only one branch that can do that, and that's our branch. Instead, I want to ask you, do you dispute that over 24,000 emails responsive to a congressional subpoena and investigation were destroyed during your tenure?
I do not.
Do you dispute that you testified before the Oversight and Government Reform Committee after that destruction that it was your intention to comply with the request for evidence and that you were planning on turning over all relevant email communication?
That testimony was not after anyone knew about that erasure.
But you testified that after that happened.
No.
Was
After
anyone
yes, I'm sorry. I did testify after it happened, when just nobody knew it had happened.
Was anyone at the IRS, including the 2 low-level employees that you keep blaming for this, was anybody fired due to the destruction of evidence?
I would like the record clear. I don't blame them. At the time, I didn't blame them. The IG did a year investigation and found
Were they
it was
fired?
a mistake.
Was
They were not.
Was anybody fired for the destruction of evidence?
Those 2 people were not fired. The IG determined it was an honest mistake on their part.
So no substantive corrective action has been taken. So ultimately, sir, I will do what you ask us to do. I will judge you on your overall record. Your inability to successfully preserve the information requested and your so-called mistaken testimony clearly demonstrates that your overall record is one of gross incompetence and extreme negligence, and that your department exhibited such. Or worse yet, there was some intentional deception. We shouldn't need the articles of impeachment that we are talking about today, and we should need these hearings because you, Mr. Koskinen, should have resigned for your failures to properly carry out your duties and for failure to bring the transparency that you promised during your confirmation hearings. And with that, I yield back my time.
The time of the gentleman has expired. The witness will be permitted to respond if he chooses to.
Pardon?
You can respond.
No, I think if I have an overall record at the IRS I'm proud of. We've made significant progress across the board. I've talked about.
You have to respond to the specific.
But on the specific issue, I do not think that the mistakes, honest mistakes made by 2 employees are the grounds for either resignation or certainly not for impeachment. If, in fact, every time an employee makes an honest mistake in an agency, the expectation is that the head of that agency should resign, we're not going to have many agency heads around.
The chair recognizes the gentleman from Rhode Island, Mr. Cicilline, for 5 minutes.
Thank you, Mr. Chairman. Thank you, Commissioner, for being here today and for your service. There's clearly no evidence that the charges being leveled at you today have any validity whatsoever. In fact, multiple independent and bipartisan investigations have found that you in no way purposely misled Congress in any of your statements. The Treasury Inspector General, the Senate Finance Committee, and the Department of Justice have each conducted their own investigations on the so-called IRS targeting scandal. And while these investigations uncovered various management problems at the IRS, there was no evidence to support allegations of criminal activity or politically motivated behavior. There was no evidence to support allegations that you deliberately misled Congress or attempted to obstruct a congressional investigation. In fact, each of these investigations found no evidence whatsoever that you acted in bad faith. Under your direction, the IRS has spent $20 million and devoted more than 160,000 hours to collect, review, and produce 1.3 million pages of documents to investigating committees. The entire record, built on multiple investigations, fails to support the allegations leveled here today. And it's regrettable that rather than dealing with the issues of criminal justice reform, immigration reform, common sense proposals to reduce gun violence, that we are taking up time of this committee for this charade. So I want to ask you, since you are here, about the political contributions of charitable foundations. First, is it legal or illegal for a charitable foundation to make a political contribution?
The law is clear. Any C3 or any C3 organization cannot make a political contribution. 527s can be in business, have to be in business totally to make political contributions. C4s, the rule is as long as their primary purpose is social welfare, they can make political contributions.
And so if a charitable foundation makes a political contribution and the IRS becomes aware of it, you go through a process in which you impose a penalty, correct?
We'd go through a process of doing an audit and an investigation to determine the details.
And if you determine that such a political contribution was made in violation of law, you impose a penalty.
There would be penalties if that was the final determination.
And in deciding the level of punishment, the kind of penalty that the IRS will impose, you look at whether, for example, it's an honest mistake or whether someone did it intentionally and then tried to cover it up. You would treat those two categories differently.
We certainly would. We would always, in any audit, hear from the taxpayer and make our responses accordingly.
So in the case of a contribution made by the Trump Foundation of $25,000, in which they made that contribution to a political action committee for the benefit of the Attorney General candidate, Pam Bondi, shortly before she decided not to pursue a criminal charge or any other investigation against the Trump Foundation, on the filing of the foundation, they put, as the place that they made a $25,000 contribution, instead an organization called Justice for All, which is a Wichita organization which they never made a contribution to, which sounds just like and Justice for All. The only inference, I think, would be in an effort to cover up an illegal political contribution. In those circumstances, the IRS would impose a more severe penalty, correct?
I don't mean to be unresponsive. As I said, my goal here today is to answer questions. But as I say, when hypotheticals start to get very specific, it's inappropriate for the IRS or the commissioner to respond.
Well, Commissioner, you have been undoubtedly following the extraordinary coverage of the operation of the Trump Foundation as it relates to these political contributions in the media, correct?
Well, I read newspapers every day.
Okay. Well, is someone at the IRS reviewing this, or will someone initiate some review of these illegal political contributions by the Trump Foundation?
As I've tried to make clear, we never talk about the status of any taxpayer. And we get referrals from the public, from members of Congress, suggesting that we look into particular activities of companies, charitable organizations, and others. There's a process with appropriate reviews and controls that goes through, but we never respond. If you write us a letter, we tell you, thank you for the letter. We don't tell you what the action is we're going to take.
Thank you.
So I can't tell you.
Thank you, Commissioner. And one final question. An issue which has been raised by my constituents with some frequency are difficulties they have when they call the IRS and they're put on hold for an extended period of time, really unreasonable lengths of time as they're waiting to speak to an IRS official. Can you talk about what efforts are being made to reduce that waiting time? And more generally, would you address the impact of the deep budget cuts on your ability to deliver services to my constituents and to constituents all across this country?
Well, if I could respond, the question was raised by the congressman from Texas about what we do with the $290 million. What we did with that was we hired, partially of them there, we hired 1,000 people during tax filing season, and the level of phone service went from 37%, a totally unacceptable rate the year before, to 70%. But because the amount of money provided was less than half of what we requested, I advised the appropriators that after the end of the filing season, the people we had hired, the money ran out and the people would go away. So our level of taxpayer service right now is back to an unacceptable level. It's a simple algorithm. If we have the money, we hire the people, they answer the phone. If we don't have the money, we don't have the people, we don't have enough people to answer the phone.
So the people who are being required to stay on those phones and wait for an IRS commissioner don't have you to blame. They have Congress to blame for not appropriating the resources necessary to serve our constituents properly.
The time of the gentleman has expired. The witness will be permitted to answer the question.
I've tried to make it clear to appropriators and the Congress that it is, we do the best we can. We have an obligation to provide taxpayers the best service we can, but it is a direct correlation between the amount of funding and the amount of service we can provide. The $900 million cuts over the last 6 years means that we are significantly constrained. We did appreciate the $290 million from the Congress, and we provided reports on how we actually used all of those funds for protecting taxpayers, cybersecurity, and taxpayer service.
Thank you, Commissioner. I yield back, Mr. Chairman.
The chair recognizes the gentleman from Texas, Mr. Farenthold, for 5 minutes.
Thank you, Chairman. Good. Is this thing? Okay. Commissioner Koskinen, you testified in response to a couple of questions that as a result of the Lois Lerner treatment of conservative organizations, several people are no longer with the IRS. Were any of those people fired, or did they all resign?
I actually don't know. All of that happened before I got there. All I know is the 5 people in the order either resigned. There were reviews done on a personal basis, and I don't know which of those people resigned and which of them resigned in the face of, in some cases, knowledge they were about to be fired. But I don't know that, and if I did know, I wouldn't be able to tell you the details anyway.
And you talked about these 2 gentlemen who degaussed the tapes, and you repeatedly said that it was an honest mistake. And so were they aware, do you know if these gentlemen were aware of the order to preserve data?
I have not done the investigation. The IG's investigation reported that they were not aware, that they actually thought these were labeled as junk, and they thought it was junk. They'd already degaussed some earlier 2 years ago, and their understanding they were junk. They came with a label saying for disposition, and they disposed of them.
And so you've testified that you got the word out as a result of the subpoena not to destroy any evidence. How did you get that information out?
The word was already out in the spring and the summer of 2013.
But how did you communicate it to the employees where when someone who is in charge of destroying a potential media that would contain these didn't get a hold of it? Was there an email?
Yes, there were emails in 2013. There were further emails in 2014. But as I've said, it shouldn't have happened. And it clearly was not an appropriate level.
What I'm getting at is the fact that this email did not get to people who actually physically destroy backup tapes seems to indicate a management failure. So I would ask that you would get us copies of those emails and who they were distributed to. You know, I realize, you know, I'm a small businessman. I've never had more than about 40 people working for me. But if we were to get an order from Congress or a court or the IRS not to destroy evidence, we'd probably pull the hard drives out of all the computers so something isn't actually erased accidentally. As an attorney, I know that a claim of spoliation of evidence really weighs against you. In Texas, you're entitled to a jury instruction telling the jury that you can assume the worst was in those emails.
I've been educated by Congressman Gowdy about spoliation since I did not know it originally. It has to be an intentional destruction for it to be assumed that, in fact, Kate you can assume the worst. There was thus far no finding that it was intentional.
I'm going to go a little bit and take a step back because, you know, we are talking about articles of impeachment against you. One of the things I hear consistently from my constituents in Texas is all you guys in Congress do is go yell and scream and beat on your chest. In fact, I hear it from some of the folks on the other side of the aisle. When we find wrongdoing in government, Congress has a limited number of remedies. We can write a law to change it, try to fix things, but that's got to get passed by the Senate and signed by the President. So if it's something the other side doesn't like, right now this Congress is out of luck. You know, people say, well, you've got the power of the purse, but the Senate won't take up our appropriations bills, and we're continued to force to do continuing resolutions and face claims of, oh, you're shutting down the government and all of this nonsense. So the power of the purse is basically gone. We had Eric Holder held in contempt of Congress. We had a committee recommend criminal charges against Lois Lerner herself. And last week, Brian Pagliano refused simply to show up. And the Justice Department isn't doing anything. So our bag of tricks is getting kind of shallow. And impeachment is in there. And I think one of the reasons we're pulling it out is that the Justice Department and the Obama administration are failing to cooperate with Congress. The Justice Department, rather than being the people's lawyer, are turning out to be the administration lawyers. And you may be the victim of this. I mean, do you have any suggestions on how we should get more cooperation from people before this committee, the Oversight Committee, and the rest of Congress?
Well, whatever the Oversight Committee is doing, they have noted on their website, or at least it was until recently on their website, 20 executives in the government that they thought should be removed or leave. They have big pictures and they have big red X's through 18 of them. So they've been successful 90% of the time. I'm one of the two that they have not thus far been able to get.
I guess the other weapon we have is are these hearings and getting the public behind us on that. And I appreciate your courage coming here and testifying, but I really am disappointed that these things happened under your watch, and the buck's got to stop somewhere. And I see I'm out of time.
Would the gentleman, without objection, the gentleman's granted an additional 30 seconds. Would the gentleman yield?
I will.
Thank you. You asked a question that Chairman Chaffetz and I would both like to pose to the Commissioner a slightly different way. Can you please provide to this committee and to the Committee on Oversight and Government Reform any written communication, not just emails, any written communication that you or anyone else made instructing IRS employees to preserve records responsive to congressional subpoenas?
Who it went to. And who it went to.
And who they went to.
Yes, no, we'll be happy to do that.
Thank you. The chair now recognizes the gentleman from Michigan, Mr. Bishop, for 5 minutes.
Mr. Commissioner, thank you very much for being here. Thank you for your time and patience answering the questions today, much of which has been asked and re-asked. I apologize if I get into that area, but I represent 770,000 constituents, all of which have an opinion about something as well as they should. But not many resonate, not many issues resonate as they have on this issue in particular with the IRS, because it impacts everyone. And the question has to do with the way in which it's hypocrisy that the IRS expects citizens to live up to a certain standard, but doesn't hold themselves to that very standard. And as a former businessman and person who complied as a citizen, I am asked to comply with the IRS. If I were audited and the IRS showed up at my doorstep and they said, where's the information? And I said, my server crashed, sorry. I don't think the IRS would be as lenient with me as the government has been with the IRS in such a circumstance. So this is what angers people. This is why a hearing like this happens. And I think this is regular order for a committee like this to bring this issue forward because, as my colleague said earlier, we have run out of options. Our job is to oversee and make sure that government runs properly and according to the law. And my frustration sitting on this committee and being a part of all this is that it doesn't operate that way, that we very infrequently have real oversight, that those that come before this committee oftentimes just stare us down and go on their merry way. They take a lashing and leave as though they've done their job. But it's very frustrating for me. I've learned that I will not accept it. This all has to change. But I want to ask you, the IRS has promised to deliver all of Lois Lerner's emails relating to the targeting of various conservative organizations, but was unable to because her hard drive had failed and substantial amount of backups, the backups were destroyed as well. And I wanted to ask you about the backups. Ordinarily, there's a forensic research. If I'm running these operations, I go and make sure that every possible remedy, every possible option was taken to ensure that we checked everything, to find everything that was asked of us. Can you tell us whether or not the IRS reviewed the backup tapes? Or any information, for example, did they go back and look at the hard drives that handled Lois Lerner's emails? Did they look at the email server? Did they look up at the BlackBerries that she had then or has now? All of these things, laptops, did she have more than one? What was done to try and preserve this information, this critical information for this committee and the American people?
As I noted, there were, all of this started, the investigation started 6 months before I got there. There were instructions issued to preserve all media, and we'll share those with the committee. The decision in 2013 trying to respond was the most likely place to find these emails was in the hard drives in all of the employees. Hard drives of 88 or 90 employees were pulled. They were reviewed with agreement with the committees as to what the searches would look like to make sure they were getting everything responsive to the inquiries. And that's how we ended up with 1,300,000 pages of documents. With regard to Ms. Lerner, there were 78,000 of her emails provided, 24,000 from that gap period. When I was advised of the gap period in April, I said we need to go and look at everybody she communicated with, because if there was an email in her box, it was on somebody else's as well, and we found 24,000.
Can I ask you this? Did she ever, after all this happened, did she ever come to your IT department and say, someone help me find these emails?
There are
Because
emails.
if my computer
Yes.
crashed, I would say it's critical, especially if I were the director of the IRS. I would immediately go to the IT department and say, please help me, something's gone wrong here, find my emails.
And there are emails in which she wrote to the sent to the IT department in 2011 saying, my hard drive looks like it doesn't work, it's crashed, could you fix it? The hard drive was reviewed and worked on by IT, and they sent her a note back saying, we can't find any of the emails. She was, according to the emails, unhappy and upset that the emails had been lost, and they said the only way to conceive of it would be to send it out somewhere with experts, and they didn't do that. But they did have, there are contemporaneous emails, which ironically were provided to everybody in the end of 2013, so it's not as if there was a conscious effort to hide the issue that her hard drive had crashed, and she had, as you said, been very concerned and asked for help to try to fix it.
Mr. Chairman, my time has expired. I yield back.
The chair recognizes the gentleman from Michigan, Mr. Trott, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Commissioner, for being here. You know, Commissioner, you've had an extraordinary career. Head of the Soccer Foundation, head of Duke University Board, executive chairman of Freddie Mac, deputy mayor of D.C., deputy director of OMB, ran a large turnaround company, was in charge of Y2K for the entire country, clerked for the chief judge for the D.C. Circuit, worked at Gibson and Dunn, Duke, Yale, Cambridge, just an extraordinary record. You've said earlier that you're proud of your record at the IRS. I'm not so sure I agree. You came in with two big tasks in front of you. One, the Lois Lerner investigation, and two, to restore the confidence in the American people that their First Amendment rights weren't being compromised by the IRS. And we've heard quite a bit today about our concern with respect to both of those challenges. But let me ask you a hypothetical. When you were the executive chairman of the Freddie Mac board, if the president and CEO of Freddie Mac, he lied under oath to Congress or repeatedly misstated important facts or repeatedly was uninformed of decisions being made by surrogate or subordinates regarding the mortgage crisis, what would you have done?
If he lied under oath to the Congress, we would have considered appropriate disciplinary action, which might have included termination.
If the president of Duke University, when they were doing the investigation into the scandal of the lacrosse team, if he had lied or if he had misstated key facts or if he was otherwise uninformed on what the subordinates were doing with respect to that investigation, what would you have done when you were the chair of the Duke board?
Well, if he was performing in good faith, you're talking about did he intentionally either mislead or obstruct issues?
Just gross incompetence, let's call it that. So
well,
let's not say perjury. Let's just say gross incompetence, unaware of the investigation, unaware of the facts, misstating the facts consistently. What would you have done?
At that point, in fact, we'd have a discussion, but that doesn't sound like he intentionally. If he was totally unaware, then you would have a serious question. This is not a situation where the head of the organization was totally aware by any stretch.
This is not a hypothetical. Let me ask you a more recent set of facts. So yesterday, Senator Warren was screaming at the CEO of Wells Fargo for what happened there to their customers. And I think it's indefensible what happened there. And she called, I think she screamed it several times. He needs to resign. Do you think the CEO of Wells Fargo should resign?
Not a decision for me to make, but the distinction is people at Wells Fargo knew for the last couple of years about that problem. No one at the IRS knew about the erasure of those tapes. This is not a situation where people knew something and were covering it up. Every time we spent a significant amount of time trying to provide all the information we had.
So you think the CEO of Wells Fargo knew about what was happening?
That's all I know is what I read in the newspapers, and my understanding is that the question was that people knew 2 or 3 years ago.
People or the CEO?
I haven't read the details, so I can't tell you for sure. Again, to the best of my knowledge, I don't know the details.
We've heard a lot today from some of the Democratic members of the committee that this whole hearing is an embarrassment and we should apologize. And here are the facts as I know them. People are afraid of the IRS. The IRS was used as a political tool under the Nixon administration and now the Obama administration. You were brought in to solve this problem, and under your watch, the problem got a lot worse, either because you committed perjury or because you were consistently misinformed regarding critical facts in the investigation, or you were unaware of what your subordinates were doing. Now, we both know, and I spent 30 years in the private sector, we both know in the private sector, the head of the organization with those facts in front of you, they would have been fired or they would have resigned. And so when the Dems say this is a charade and a game, and you could say the same about a lot of things here in Washington, but my question to you is, what should I go home on Friday and tell my constituents who are afraid of the IRS and who are disgusted by Washington? Because what happens when these facts are presented in Washington is either people lie, they cover up, or we have to say, well, you know, we have to expect some level of incompetence from the federal government. That's why Washington's a mess. What should I tell my constituents about what's going on at the IRS and how, under your tenure, this investigation played out? Please give me an answer.
The answer to that is no one lied, no one covered up. And in fact, the base issue, the mismanagement that led to the totally improper designation of organizations by their names has stopped, notwithstanding the issue that there are 3 that have litigated and have not been decided. We are actually resolving those. So I think the answer is no one lied, no one covered up, and in fact, we take very seriously the obligation to make sure that every taxpayer, no matter their political party, their beliefs, whether they go to church or not, whatever they do, deserves to be treated and needs to be treated, and that's our obligation to treat them fairly.
But, sir, you'd have to agree with me. In the private sector, the head of that organization probably wouldn't have survived. Would you agree with that statement?
On these facts, the head of that organization would survive.
I respectfully disagree. Thank you again for your time. And I have to say, I'm surprised that you haven't resigned, because with your extraordinary career, I think there's a part of you, if you disagree with a lot of what we're doing here today, would want to say, gosh, I just don't need this, and you'd move on and do something else. But I appreciate you being here.
I appreciate that. As I've said, if I could, Mr. Chairman,
answer.
I have not resigned, A, because I don't think anything has been done that would merit that. B, after all of the tugging and hauling and pushing over the last year and a half, my concern is if I am in fact forced out and I left, it will simply create a terrible precedent trying to recruit people from the private sector as I came, on the ground that people can make allegations that are not necessarily subject to a full investigation, can simply make allegations charging you that with threats of impeachment or censure, and a lot of people are going to say, why should I risk my career or my reputation to do public service in that context? So my sense is we need to get to closure on this because I don't think impeachment is proper, and we need to demonstrate to people you can come into public service and you have an obligation to the taxpayers. You spend taxpayer money. You have an obligation to do your best and perform well. And in some cases, as we noted, there's on the Oversight Committee list, there are 18 out of 20 that they have so-called targeted that have left. And if you can't meet the expectations, you don't make progress, then you shouldn't be there. But the total record here is not just C4s where we have solved that problem. The total record over the last 3 years is the IRS and its employees have made tremendous progress dealing with a wide range of issues, and I'm proud of the record.
The chair recognizes the gentleman from Wisconsin, Mr. Sensenbrenner, for 5 minutes.
Thank you very much, Mr. Chairman. Mr. Koskinen, first of all, thank you for coming here. I think that you have been able to present your side of the story in a very articulate manner in response to both friendly and hostile questions. I want to make an observation before asking a couple of questions. This administration has made a career, or maybe history, of basically ignoring whatever Congress wants to do in furtherance of its constitutional oversight responsibility. That includes blowing off subpoenas, delaying things, not having full disclosures, covering things up. And in the case of Lois Lerner, who was cited for contempt, the U.S. Attorney announced that he would not present the contempt citation of a separate, coordinate, and co-equal branch of the government to the U.S. District Court for the District of Columbia 30 minutes before he left office following resignation. That, in my opinion, is an impeachable offense. But since he left office 30 minutes after he committed the offense, there was nothing that Congress could do. You know, I think we have to look at ourselves. One of the things I think we should do is to allow the counsel for the clerk of the House to be able to go directly